Hi everybody, it's Michael Blake again, patent attorney in Milford, Connecticut. Today I'm going to talk about how do you choose between a provisional patent application and a non-provisional utility patent application. In my previous videos I talked about the different types of patent applications, and a provisional is like an informal, quick patent application that only lasts for a year. The non-provisional utility patent application is the normal type of patent applications most people think about when they think about patents. And a non-provisional utility patent application is the one that the patent office will examine and that will eventually issue into a patent if things go well. So how do you decide between a provisional and a non-provisional? Well, one factor to consider is, do you need time to find investors? If you're in a very early stage of your invention and you want investors to help you develop and market the invention and also maybe pay for the patent costs, you may file the cheaper, generally provisional patent application. Do you need time to test the market? For instance, do you need to find out whether or not your invention is going to be successful? So you may want to get some sort of protection, but not the full protection of a non-provisional, which costs a lot more. So therefore, you may want to file a provisional patent application before you test the market and disclose what your invention is to the market. So one way of testing the market is trying to sell your product that's protected by your provisional or non-provisional patent application. If you test the market without any sort of patent protection, then your invention is out there in the public and other people could steal it and maybe even file their own patent application on your invention, which would cause you a lot of problems. And if over a year goes by, you will lose your rights to that invention as far as filing a patent application. So the best bet would be to file a provisional patent application if you just need to test the market and you don't want to spend a lot of money. Do you need time to find a licensee? For instance, if you're thinking that you don't want to manufacture the device that's protected by your invention, and you want to find a licensee who will manufacture it for you and maybe pay you a royalty for every sale they make, then a good option is to file a provisional patent application first and then go show it to a potential licensee. That way you're protected because you have patent pending status, and it's much harder for the potential licensee to steal your invention. Now, if you plan on making and selling the invention yourself, I usually recommend that the inventor file a non-provisional patent application. This is because if they're going to make and sell it themselves, then they don't really need to do the extra step of filing a provisional first, which does cost some money, even though it is cheaper than a non-provisional. You still have to pay to have it prepared and filed, and that could run somewhere around $2,000. And then a year later, you prepare and file the non-provisional, which could run anywhere from another $5,000 to $10,000. So you could save that cost of the provisional simply by filing the non-provisional first and skip the whole provisional process. Another factor to consider is, do you need to delay costs? If you do, then filing a provisional is a good choice. Another factor is, do you want to save the total output of money with respect to your patent protection? If you do, then skipping the provisional and going straight to the non-provisional will save the total output of money because you're not paying for that provisional patent application. If you've come up with an invention and at some point you find out that you are aware of potential infringers who are copying your invention, then whether or not to file a provisional or non-provisional, generally the answer would be that you want to file the non-provisional because that will issue faster, and then you can sue those potential infringers or at least send them a cease and desist letter, especially after your patent application issues. You could also send them a letter during the pendency of your patent application, but they may not take you seriously and you can't sue them until your patent actually issues. So those are the factors you should consider when trying to decide whether or not to file either a provisional patent application or a non-provisional patent application. Remember, I'm Michael Blake in Milford, Connecticut, and I have my own patent and trademark practice. Thank you.